Today, the parties present an argument on the People's Exhibit 999. It's P-TR-999. I had a chance to review this exhibit over the weekend, and I had a chance to consider the arguments that the attorneys made yesterday after the jury left. There are two reasons that the people rely on in arguing that this exhibit should be admitted. And by the way, this is a surveillance video at University Hospital, and there appear to be two cameras. One camera is outside the hospital and depicts what I believe to be an ambulance bay sort of area. And then there's another camera that appears to be immediately inside the hospital that shows people entering the hospital through that entrance. And so in this case, the video shows patrol cars and unmarked vehicles, law enforcement vehicles, pulling up at different times. Initially, you see one car, and then someone is helped out of the car. It appears to be someone who was injured or has been injured. The people have submitted that this was someone who was injured in the shooting. And then I think other patrol cars arrived shortly after that. The first patrol car is a marked vehicle, and then you see, I think, 3 or 4 more patrol cars arrive shortly thereafter, and again, injured individuals are taken out of the car. There's a point at which medical personnel come out. They're in a hurry. They have a gurney, more than one gurney actually, and they help people out. At some point, those cars leave, and then there are unmarked cars that show up, and there's one that shows up, and then 3 more show up shortly after that, 3 or 4 more. That's generally what the outside camera shows. The inside camera shows people either walking into the hospital or people being wheeled into the hospital on a gurney, and you see medical personnel running around. You see medical personnel wheeling people in or walking people through the entrance into the hospital. There are 2 reasons that the people argue this is admissible. One is that it shows the injuries to some of the victims, the named victims in the shooting. And so let me address that argument first. And then I'll address the second reason, which is that it shows the transport of injured individuals from the theater to the hospital in patrol cars or unmarked vehicles. In terms of the injuries, it is true that you see some what appear to be injuries in the video, in the surveillance video. I disagree that this is the best evidence of the injuries. It's perhaps the video evidence that is closest in time to the shooting, but that doesn't necessarily make it the best evidence of the injuries. By way of example, if you had pictures taken from a helicopter immediately after the shooting, those would be the pictures taken closest to the shooting, but they would not necessarily be the best evidence of the injuries, because you probably wouldn't be able to see any injuries from such a long distance. In this case, it's a surveillance video, so it's not good quality, and you don't see a lot of detail. You do see what appear to be bloody areas on some people. There are a couple of people in particular who are wheeled in on a gurney, and you can see what appears to be a relatively large bloody area on their body, and so you infer from that it's an injury, but you don't see what the injury is. You don't see any detail. You just see a bloody section. So I disagree that it's the best evidence. So it's not the best evidence, in part because it's poor quality, since it's a surveillance video, in part because of the distance between the camera and the injuries, and also in part because people are moving. And so this is a video, and it's not like a photograph where someone's standing and you're able to take a still picture of the injury. This involves people being moved and people moving, and you don't get a particularly good look at the injury. So that's one thing. The second thing is that it's cumulative. Mr. Orman mentioned that the prosecution has been able to identify the following individuals depicted in the video: Michael White Jr., Michaela Hicks, Caleb Medley, and Jessica Gowie. And I believe that people have either introduced pictures of the injuries that these individuals sustained, or will be introducing pictures and other evidence of the injuries that these individuals sustained. It is true that the surveillance video is evidence of the pre-treatment injuries, but that's not necessarily what's most relevant. What's most relevant is the nature, character, and extent of the injury. What is most relevant is what is the actual injury. Now, I have allowed people to testify about what they experienced in the theater. I think that's fair game. I think people who were injured can say, I noticed all of a sudden that I had blood in my arm and I felt a burning sensation, or I saw a hole in my leg, or whatever it may be. I think that's okay. I think that's appropriate. And I think it's appropriate for them to describe that. In this case, as I mentioned, although they are pre-treatment injuries, it is really difficult to see any details, and it's difficult to tell what the injuries are. So it's cumulative with respect to all those folks, because the people have evidence of the injuries that are actually better in terms of identifying what injuries were sustained. There are people who are shown on the video who are not identified. And I have allowed some evidence about that. I allowed it from the first responders, but I also limited that at the defense's request. After I think 2 or 3 first responders have talked about different areas of the theater and different aspects of what they did, I told Ms. Pearson during a bench conference, I said, from here on out, if you want to call a first responder, you have to be able to identify for me something new, what it is they're adding to this. They can't just keep coming in here and saying, we got there and it was chaos and there were a lot of injured people and people bleeding, and there was an alarm that was going off, and there were weapons on the ground. At some point, that becomes cumulative. And so I told the prosecution, if you want to call another first responder, they're going to have something new to add to what has already been presented. I have allowed named victims to testify about seeing unidentified individuals injured, but I see that as different. Each named victim had a different experience in a different place in the theater and perceived different details about the shooting and about the aftermath. And I think it's fair for a named victim to talk about what he or she remembers happened, about what he or she perceived during the shooting and immediately after the shooting. And so I see that as different than just having first responders come in and keep talking about the same thing. The point about having first responders is to describe the scene immediately after the shooting, the crime scene. And that is allowed, but only up to a certain point. There comes a point when it becomes cumulative, and I drew that line. I think with respect to the named victims, it's a little different because each one of them is perceiving different things, and they're not coming in here just to talk about the crime scene. They're coming in here to describe what they experienced, to describe what they saw, what they perceived, what they remember, how the shooting happened, what they did during the shooting, what they observed, what actions they took and why, and how they exited the theater and what they saw at each point throughout. The second reason the prosecution submitted this is relevant for is the transport of the injured victims to the hospital in patrol cars and unmarked vehicles. And the prosecution is right. It is relevant to that. It is the best evidence of that. But that's a tangential issue in this case. This is not a primary issue. And it's something that has been talked about. It's something that's not in dispute. And it's something that's not at the heart of the case. And so I have to take that into account in determining whether to admit this. And I also take into account Rule C-200. By the way, I should have mentioned that when I was discussing the injuries that may be shown on the video on P-TR 999. I issued an order C-200, that sets some parameters in terms of what evidence is admissible with respect to injuries. And to the extent that there are objections, contemporaneous objections, I've been doing my best to rule on those objections consistent with Order C-200. Lastly, I have to look at the risk for prejudice. I just addressed the probative value. The risk for prejudice here is that, number one, you see on at least 2 or 3 people what appear to be large bloody areas on people's bodies. And you can't tell what injury it is. And so in the end, you just don't end up with something that appears to be a person with a large bloody section on their body. That can be prejudicial. You also see a lot of cars showing up. And you get the impression that, boy, there sure were a lot of injured victims in this case. And there were. But that's not a point that the prosecution is entitled to keep emphasizing just for purposes of emphasizing it, to get sympathy or for purposes of prejudice. Of course, it's allowed if there is a probative value that is not substantially outweighed by the danger for unfair prejudice. But here, there's really, the probative value is substantially outweighed by the danger for unfair prejudice. Again, the impression you get is it's driving again the point of this was serious, people incurred some very serious injuries, and there were a lot of people who were injured who are being brought to the hospital and wheeled into the hospital, and then you see the medical personnel running around clearly conveying that this was an emergency situation and that it's not your typical type of situation with so many injured people being brought into the hospital. That point has been made. The jury understands that now. There has been evidence now presented with respect to that. And so that's something that I have to consider in determining admissibility under Rule 403. Rule 403 favors the admission of evidence, but it is also an important tool to exclude matters of scant or cumulative probative force. That's what we have here. We have matters of scant or cumulative probative force. If we didn't have other evidence of injuries with respect to these folks, or perhaps with respect to other folks, I may agree with the prosecution and say, you know what, this is the only evidence that they have that folks were injured, and this is the only evidence of the injuries available, and so that the probative value is great. And so in that case, I might come to a different conclusion, but that's not the situation here. So this is no different than what we talked about earlier when Ms. Pearson was at the bench and she was trying to admit, I think, the sandals that Veronica Mosher-Sullivan was wearing on the date of the shooting, and her earrings. Yes, they are things that she was wearing, but what's the probative value? What does it go to other than she was wearing them? And then there's the risk for prejudice that those items carry with them. I have to compare the probative value against the risk for unfair prejudice and some of the other concerns that are listed in Rule 403. So for all those reasons, the objection by the defense to P-TR 999 is sustained on relevance and Rule 403. So, Mr. Orman, I'll give you back the disc, and if you want to mark it as a court trial exhibit, you may do that, unless this is a copy.
That is a copy, Your Honor, and I would like to mark it as a court trial exhibit just so that we have a record of that, and I don't know what number we're up to.
I think we're up to 30.
I can retrieve it, I'll have my paralegal make a marking for it. And maybe, or do you want us just to write on it with a Sharpie since it's a disc and we can do it that way?
Whatever you want to do.
I have a sticker. If actually I can approach, we can
Yes.
put the sticker on there.
Here you go.